Well, thank you very much, Mr. Speaker. I very much appreciate the opportunity to speak on this very important motion. And I want to thank the government for the opportunity to debate. And I hope perhaps with the opportunity here to speak first this evening that I can set perhaps a little bit of a different tone than the tone we had earlier this afternoon. And you know, unfortunately, I think it got a little political this afternoon. So I'm going to spend just a minute or two sharing my thoughts on whether or not I feel like we've been given enough time here to debate and discuss what is a matter of great importance and interest to Albertans. And I have to say I have some sympathy for the perspective that perhaps this has been rushed and that perhaps it would have been nice to see these regulations sooner. But I have to say that this is an issue that is evolving on a not even daily basis, perhaps even more often than a daily basis here as we get towards the deadline on Monday. The federal government has yet to pass their legislation. It made it through the House of Commons today, but is yet to make it through the Senate. And as a result, my sense is that this government is working up its regulations as it goes and as it responds to the changing landscape and the Bill C-14 that's coming from the federal government. And so as a result has had a challenging time getting much more information to us ahead of time. And this is the first time in my relatively young political career here in the Legislative Assembly that I've actually seen a regulation and an order in council before it's passed. So I think that it's important we recognize the government, I believe, has the best of intentions in sharing this information with us ahead of time. I think that represents some new ground for a governing party, at least in recent memory. So I think they deserve some credit for doing that. The one suggestion, perhaps, if we were to go back a few months in time, I'm sure we all wish we could do that at times, would have been perhaps to spend some time a few months ago having this debate in a more general sense. What I can say, though, is when I found out from the opposition House Leader that we would be having this debate this week, I found that out last week, I went and I started talking with stakeholders in my constituency, and I started talking with stakeholders in the palliative care world, and I did my own research and I did some thinking about this issue. And I would hope that in that time, between about a week ago and now, that other members would have done the same thing. We were given the draft motion on Friday, so that gave us a sense of the frame under which we would be talking about this issue today. So, you know, on balance, frankly, I think we have had enough time to review this, and it is an issue that we're up against the clock. Whether we like that fact or not, that's the situation we're in. These law will change on Monday of next week, and so we have a need and a requirement to have these discussions. So let's then talk about medical assistance in dying. That's the issue before us. Now that we know it will be legal, my opinion, as I've said in my member statement of March 17th of this year, that the medical assistance in dying, we know, will now be legal. I am philosophically supportive of the idea that people have control over their own medical decisions all the way through life, up to and including death. But now that it is legal, I believe we need to emphasize the fact that medical assistance in dying ought to be rare, exceedingly rare. And when I hear people ask for that medical assistance in dying, what I believe many of them are really saying is they want to be comfortable, they want to know that they remain in control, they want to know that their families will not suffer or worry unduly. And that is what palliative care offers to Albertans. That is the purpose of palliative care. We, I think, should use this debate as an opportunity to have a discussion about how we maximize the availability of palliative care for Albertans everywhere in this province. That we talk about alternatives, prevention, reduction, alternatives to medical assistance in dying, to the request for medical assistance in dying. It will become legal on Monday, and my personal opinion is it should be legal. the Supreme Court of Canada has told us that it will be. It's important then to know that Alberta Health Services has developed a provincial palliative care and end-of-life framework. That framework exists and has been in place since, I believe, 2014. But that framework has not been properly and fully funded. What that framework talks about is improving access for patients and their families to palliative home care, and it talks about the need for early access to palliative care. The objective is to achieve a quality of living, to reduce the desperation that people feel that leads to that sense that the only way out to relieve that suffering would be medical assistance in dying. There are other alternatives where you can maintain control, where you can choose, where you can maintain quality of life to the end of life. And I would encourage this government, please, to consider the importance of expanding palliative care throughout the province and ensuring that all Albertans have that choice. And as I look at the specific regulations, there are a few things I think that it covers that I am supportive of. I do have some questions exactly how that mental capacity will be determined. It sounds like that physicians and psychologists will be involved in that. I'm glad to see that mental illness is excluded. The question that was raised earlier this afternoon is the question of the delay, the time delay. And talking with people in the palliative care world who work in palliative medicine, they say that there are cases where someone may be in great distress on a given day, and they feel like it's time to end it all, and they want to make that choice where, given 24 hours and some pain relief, they're sitting up, drinking a cup of tea, talking with their family the very next day. And I think we need to ensure, and I would encourage the Associate Minister of Health and the Minister and all members of the House, anyone who may be involved in this process, please to consider working in some sort of even brief delay from the time the request is made to the time that medical assistance in dying actually happens. I recognize that there is an opportunity all throughout the process for the patient to change their mind right up until the very last minute, right up until the drugs are administered. And I appreciate that fact. But I would suggest that we perhaps look at building in some sort of formal delay mechanism. It doesn't need to be a matter of weeks, perhaps a matter of 48 or 72 hours. It doesn't need to be necessarily a long time. But I think it's important that a decision such as this, an irrevocable decision such as this, is taken with real caution. The guidelines talk about, or the rules in place talk about the safeguards that would be in place. And I just want to read some of those into the record to make sure that it's understood what those safeguards will be. The College of Physicians and Surgeons of Alberta have included several safeguards. That the patient must be made aware of all of their medical options beyond medical assistance in dying, but including that as well. That 2 separate doctors must meet the criteria as set out by the Supreme Court. Any questions about mental state raised at any time must be referred to a psychologist or a psychiatrist. That 2 people must witness the patient's request, but may not be related to them, may not be their physician or the owner or operator or employee of a health facility where the patient is receiving treatment, to ensure appropriate independence. And, as I've said before, the patient must be advised at each step that they may change their mind, including immediately before the procedure. Now, we had a good discussion earlier this afternoon about the text of the proposed order in Council, about perhaps those same conditions would be included in the provision 2.2 of the order in Council, which allows for another person to sign and date the request should the person requesting medical assistance in dying not be physically able. That's not mentally incapable, but not physically able to sign. Someone over 18 years of age may sign on that patient's behalf, but I would suggest perhaps the safeguards that I have just discussed, we may want to consider putting those in place as well for anyone who may sign such an order on behalf of the patient. Now, I want to talk momentarily about the protection for vulnerable people. That is something I think that is, without question, vital to this discussion, and one that I think we must not take lightly. It is something that in the regulations and in the standards of practice as put forward by the College of Physicians and Surgeons, I know has been given a lot of consideration, and it's, I think, will be covered, I would hope, by both the professional ethic of the physician and other medical professionals who'd be involved in the process around medical assistance in dying. The specific service that will be the medical assistance in dying care coordination service. I know we'll consider that as an important part of what they do as well. But that is something that must absolutely not be taken lightly, because there's always a concern that risk could be raised. The question of the words that are often used is conscientious objection. I actually take a bit of issue with the term conscientious objection. It somehow implies, or can, I suppose, in some interpretations imply that there's an objection to something that is broadly seen as a good thing, and so that language I struggle with. That language doesn't appear everywhere, but I've seen it in a few different places. I prefer a discussion about adherence to moral commitments, and I would say that all people on the medical side who have anything to do with the medical assistance in dying, be that a participant in the dying medical assistance in dying care coordination service the Alberta Health Services is putting together, or a physician or other medical professional who chooses not to be a part of this. They are adhering to their moral commitments as they understand them. It is not up to us to judge that person or their motivations, but it's important we honor and enshrine their ability to act in a manner consistent with their moral commitments as they interpret them in their role. Fortunately, the College of Physicians and Surgeons have considered exactly that in their standard of practice on moral or religious beliefs affecting medical care. And they've laid that out, I think, very, very clearly and succinctly. And it is, I think, following an established practice that already exists within the medical profession for areas that extend beyond medical assistance in dying. I'm going to take my last 90 seconds here, Mr. Speaker, to just talk one more time about the importance of having conversations with your family, with your loved ones, with your care providers, all the way along the process, and to have those conversations now, while you are fit and healthy, about what quality of life means to you. So when decisions need to be made, perhaps you will be able to speak for yourself, perhaps you will not be able to speak for yourself. I encourage you once again to visit the AHS website, conversationsmatter.ca. These are very difficult discussions to have, but they're very important discussions, so your family, in particular your family and your loved ones and your care providers, know what quality of life means to you. There's a series of templates and documents and conversation guides that you can use at that website to help you work through these challenging but very important conversations. That advanced care plan is a very important gift that you can give to your family. I'll end by saying that death it's a natural part of life. Living a good life involves having a good death. And palliative care, advanced care planning, that can ensure that you and your loved one's choices are respected. And as I say, advanced care planning truly is a gift to your family.